Rule 60, B2. Newly discovered evidence that with reasonable diligence could not have been discovered in time to move for a new trial under Rule 59B. And 3, fraud, whether previously called intrinsic or extrinsic misrepresentation or misconduct by an opposing party. Now, when I attempted to submit this to the Court of Appeals directly, I was obstructed, as I have been several times, and I have gone on the record since November of last year, saying I understand it is an attempt at extortion in a kickback scheme. I've proven it. I proved it in December. I proved it again in February. I can and will not kick back to the local district court, especially after what I found last night. I ended up receiving a letter in the mail. Presumably, this letter was from the actual United States Court of Appeals 5th Circuit Office of the Clerk. But this letter is dated for the same day as the filing itself. Almost as if this wasn't actually connected to service of process, but that they already had it, that they were remotely observing me, and in the remote observation had coded it and timed it so that this would be time-stamped from New Orleans on the 3rd anniversary of me being trafficked to Dallas, but in a manner that would do what? Void my effort at legal redress? No. I contend they swapped it out again, so somebody else's case could use this as a loan. They talked about me signing up for a website I did not sign up for, and said that I could not proceed unless I kicked it back to the local court. Under the terms of Rule 60, I have within a year of the final judgment order to submit, or if new evidence comes to light, to submit for relief from a judgment order. In this case, the judgment order is in connection with a request for new trial. I maintain that not only is my cause a just cause, but that the crimes that were committed in obstruction of my original cause since 2017 and what actually justifies the new trial are so extraordinary and so important that I can and will not allow myself to be subjected again to another effort at extorting me to make a kickback locally that ends up having disastrous consequences. This is not covered by some sort of intelligence or state secret. It has gone way too far for that. Insofar as there might be a consideration calling it for a request for writ of certiorari, my understanding is I had already submitted a claim directly to the Supreme Court of the United States and was specifically informed to resubmit in the local district court. I did that in connection with request for new trial and was subjected to crimes specifically regarding the insertion of an intentional obstruction of due process by a magistrate judge and then another magistrate judge in manners that not only violated the local rules but refused to address the profundity of the actual implications of the charges and were not in any way, shape, or form qualified for consideration before a magistrate judge. Period. Everything else about the actual argument, about the evidence, about the actual charges has been intentionally obstructed for more than 4 years. And my understanding is that they took my case and they sold it. I don't even know how you do that. I don't know how you take somebody else's case that's still pending, by the way, and you sell it. To whom do you sell it? This was not a product. This was not a bid. And every step of the way, it has been intentionally obstructed. Now, we're at a situation where there has been no demonstrable actual effectiveness when it comes to an appropriate consideration of this case. And my understanding is it has been used to actually interfere with efforts at redress involving other countries. But the facts of the case are even more harrowing now, and the lack of due process and consideration of them, while other cases have been allowed to move forward that refuse to deal with the implications of what the original charges were, which had to do with illicit patterns of distribution of controlled substances as part of a pattern of racketeering activity that, among other things, engaged in intentional and willful efforts to defraud federal programs when it came to administration of services for women and children seeking assistance from homeless and domestic violence shelters, and how this correlated with an understanding of implementation of selective aspects of the Affordable Care Act and refusal to address what appeared to be an operationalization of a criminal conspiracy that was sought to be accomplished in connection with and through a justification in association with violations even of the Affordable Care Act. Represented a pattern of racketeering activity was literally trafficking people in order to extort or entice people to agree to engage in illegal drug distribution. And that's what has been happening up until this time. And now we're not only just talking about prescription medications for people alleged to have some sort of mental illness, but we're talking about how that specific nexus of crime is connected to other crimes, very serious crimes, and actually reveals that there was an intentionally orchestrated criminal conspiracy aimed at defaming certain groups of people in order to extort them into cooperating with crime and dispossessing them of their constitutional rights altogether. There's absolutely no just cause for denying me anything close to due process or even an appropriate response to reports in over 5 years now. This is not only an act of retaliation, but this is an effort at the usurpation of the government. There are ongoing intentional efforts to undermine the federal government and try to extort people into agreeing to cooperate with it. Now, here's the thing. If you really wanted to disband the federal government and allow for people to take up arms in order to assert their land claims within the United States, then you should have said that. You should have said that the federal government has abdicated its claim that it is bankrupt and that it is not willing to uphold the Constitution anymore for whatever reason. But you didn't do that. So every day you maintain as if you are in a constitutional government and attempting to compel people. That is, if nothing else, taxation without representation. And that is not acceptable. And it is not acceptable to try to force people into medical treatment under false pretenses so that you can obligate them to illegal debt. And in the course of obligating them to illegal debt under false pretenses, dispossess them of their personal private property or even their rights to determine under what terms they engage a contract so you can make them the property of other people. That's a violation of the 13th Amendment.